Good afternoon, everyone, and welcome to the first event in the 2023 In Conversation series hosted by the Justice Center for Constitutional Freedoms. I'm really glad that you could spare an hour or an hour and a half of your time to engage in a conversation about emerging social, legal, and political issues in Canada. I'm glad that you could join us for this conversation about freedom and the Emergencies Act, what we've learned from the public inquiry. As you know, the final report of the Public Order Emergency Commission was released to the Canadian public a week ago today. And I'm sure that you have all read the 2,000-page document in preparation for today's discussion. So events like this are possible because of Canadians like you. The Justice Center is entirely funded by generous donors across the country. If you're not an active donor, I would invite you to consider becoming one. We all have a great time together. Feel free to visit the Justice Center website and consider donating today. So before I introduce our speaker to you today, I just want to describe this conversation and how I hope it will proceed. So after an introduction, we will hear a presentation from lawyer Hatim Kheir on the final report, and then we will have a question and answer period. We're going to do things a little differently today. If you would like to ask a question of Hatim, I would invite you to submit your question to me via the chat in Zoom. So just ask your question there. We'll then select relevant questions and invite those who ask them to turn on their cameras, turn on their mics, and ask the question themselves of Hatim. So you'll actually have a chance this time to talk with our speaker and engage back and forth. We have 185 Canadians signed up for today's discussion, so I would invite you and encourage you to ask civil and economical questions. We want to hear from everyone today. So again, please submit your questions to us via the chat function. We'll select relevant questions and invite you to turn your camera and ask them yourselves. Okay, it is now my pleasure to introduce to you today's speaker. So our speaker attended law school at the University of Toronto. During law school, he worked at a legal aid clinic, providing legal help to students and people charged with criminal offenses. After law school, he articled with the Crown in Ontario and worked on criminal appeals. He then spent a short time as a prosecutor in Hamilton, Ontario, before joining the Justice Center. Our speaker was also of counsel to the Justice Center at the historic Public Order Emergency Commission in Ottawa last year. So he is very well positioned to address this topic today. So everyone, please join me in welcoming for our conversation, Hatim Kheir.
Hello, folks. Thank you for setting aside the time to come and listen to me talk about the Public Order Emergency Commission's report. So I'm just going to take a moment here. I'll share my screen. Okay. So as you'll see, I've titled it the Rouleau Report because that is the name of the commissioner. Justice Rouleau is a justice on the Court of Appeal for Ontario, and he was appointed for this specific task to essentially run inquiry. So today, what I'd like to do is separate my talk into 5 basic parts. The first thing I want to address is the bottom line. I just want to, I'm sure we've all heard about the conclusions of the report in the news, so let's just address that right up front. And then I'll talk a little bit about the structure of the report and maybe give some direction to anyone who might be interested in taking a look at it. And then the bulk of my talk today will be about the analysis and the findings that Commissioner Rouleau makes and why he makes them. So I'll talk mostly about whether or not he thought the declaration of emergency was justified. And then I'll talk a little bit about some of the powers that flowed from that declaration. And then I want to actually address some of my own thoughts about it and some reasons that I think it was maybe unjustified or reasons I think they have got it wrong. And then a little bit about some of the recommendations made. There were over 40 made, so I'm not going to talk about all of them. I'm just going to address some that I think are particularly interesting and particularly relevant to issues of liberty more broadly. And then I'll end with some thoughts about sort of what this means going forward. My goal, my hope is that today I don't want to necessarily, I will talk about some of my own opinions, but I would also like to just address what the commissioner found. I mean, I'm not trying to propagandize anyone. I'm hoping to to help people understand why he found things the way he did. And I'll share my thoughts, but ideally at the end of the day, I want everyone to draw their own conclusion. So we'll start with the bottom line. Like I said, this is really the paragraph that sums it up. The commissioner found that essentially the government had a reasonable concern about the risk that the protests posed, and that they had a reasonable belief that an emergency was present. And it really comes down to this one last sentence: the decision to invoke the act was appropriate. If you're interested enough to have come and listened to this talk, you've probably already heard about this in the news. So we'll dive into why this is, and we'll break down the commissioner's reasoning. So the report itself is, as Luke mentioned earlier, it's 2,000 pages long. It's separated into 5 volumes, though. So if you actually did want to take a look at it yourself, you don't have to go through all 2,000 pages. Some parts are maybe more relevant to why you might be interested than others. So volume 1 is the executive summary. So this kind of sums up everything else that's in the report within a few hundred pages. So if you're going to pick something up, this is probably the best place to start, and it's a bit more accessible. Then volumes 2 and 3 cover the analysis. So volume 2 is the first part of the analysis, and it breaks down some of the facts about the protests, their origin, and the response to them. So if you're interested in the fact, what exactly happened in Ottawa and around the country, this would be, you might look. Volume 3 continues the analysis, and this is actually where the commissioner discusses whether or not the declaration of emergency was justified, why he thinks it's justified. He talks about the use of the emergency powers, and he concludes with his recommendations. So this is actually the bulk of my talk today will be looking at things from this volume. Then the fourth part talks about the commission's process, just how it was run, and essentially from its constitution at the end of April of 2022 to the report being tabled just last week, and covers that process. And then volume 5 is policy papers. So these are actually papers that the commission reached out to academics on different issues to write. And then they've been on the website actually for months. It's just compiled them into one volume here. So let's dive into the meat of it then. In terms of the analysis, the question of whether or not the declaration of emergency was justified is really a question of whether or not the legal threshold established by the Emergencies Act was met. So my hope, I actually hate putting lots of words on PowerPoints, but it's going to be a lot of that today, unfortunately, because I want to show you what's actually on the screen. But I'm hoping we can simplify it and put it together in a way that makes sense. So we'll start with the Emergencies Act. Says that Section 17 sets out the standard that the government had to meet 4 different kinds of emergency. Some of them relate to things like natural disasters or war, but the one that was declared in this case was a public order emergency commission. So the relevant things here are that the government has to believe on reasonable grounds that a public order emergency existed. So that phrase, reasonable grounds, we'll come back to it as kind of a running theme. But it's a term that has meaning in law. It comes up in criminal law, for example. So if the police want to search you, they have to have reasonable grounds to do so. And it means something more than a possibility. It's like a probability something is true, but it's less than 50%. So it's a good reason to believe that something, but it's short of being certain that something. In this case, the had to order emergency into that arrives Canada that constitutes a national emergency.
Sorry to interrupt you, Hatim. I believe some of our listeners are having some trouble hearing you. I myself am having some trouble hearing. Maybe it's a microphone issue.
Okay, I'll try to get a bit closer to my microphone. Hopefully this makes it better.
Yeah, I think we've missed about maybe the last 15 or 20 seconds from you.
Okay, just as I have highlighted on the screen, what the government has to show is that they had reasonable grounds to believe a public order emergency existed. Reasonable grounds is a standard that's essentially a probability that something is true. And the Act defines public order emergency as having these two components. There have to be threats to the security of Canada, and they have to be of such a magnitude that they constitute a national emergency. So each of these terms are in turn defined in the Act. So we'll look at both of them. So starting with threats to security of Canada, if you look up its definition in the Emergencies Act, it points you to that Act. So to the CSIS Act, we find that there's 4 different threats to the security of Canada can exist. There's a lot of words on the screen. We'll simplify it here. It basically comes down to either espionage and sabotage, foreign influenced activities, threats or the use of serious violence for the purpose of achieving a political or ideological objective. And then the last one is overthrowing the government with violence. So in this case, what really matters is the third one there, because this is what the government said happened. So this is in their own words, this is the justification that they were relying on. In terms of a national emergency, there's 4 different components to what makes a national emergency. There's a couple options that the government can choose, but they chose A here. So we'll take B out of the picture. And really what we're looking at is an urgent and critical situation of a temporary nature. It has to endanger the lives, health, or safety of Canadians. It has to be such a big deal that the provinces can't deal with it themselves. And lastly, it also can't be the case. It can't be dealt with under any other law of Canada. And that bit, the law of Canada, you could think about it 2 different ways. I mean, on the one hand, it might mean any law that exists in the country, or on the other hand, it might mean specifically federal laws. And so the commissioner found that it means federal laws only. And his reasoning was essentially that the provincial side of things is covered by the previous point. So he takes all these points together and he summarizes this as the legal test. This is what the federal government had to show to establish there was an emergency and to use the powers that they used. They had to believe on reasonable grounds that there was an urgent situation that seriously endangered lives, health, safety, that it arose from threats of the use of serious violence for the purpose of political, religious, ideological objectives. In this case, political would be the one we're concerned about. That it's such a big deal the provinces can't deal with it, and that the federal government also doesn't have laws that they can effectively deal with it. And then the last bit of requiring special temporary measures kind of follows from everything. So if you have a situation that meets everything else, you're probably going to need some special measures to deal with it. So let's into each of these. So in terms of a critical and urgent situation, the commissioner says these 4 things made the situation what it was. There was the impact of the protests on local residents. So he talked about things like things we've heard in the news, the horn honking, diesel fumes, protesters kind of the night. In terms of some other relations, just the way it limited protest. So for example, at Coots, the block people from Coots being able to get to a town that had a lot of things they needed. He highlighted a risk of violence at the protests, the impact of border blockades on the and the risk of conflict from counter protests. So I just want you to keep in the back of your mind the risk of violence and the impact of blockades. I'm going to come back to these when I share some of my own thoughts. The next point we want to look at is the issue of serious violence. So one big point that the commissioner found is that it has the same definition under the CSIS Act. That may seem like a silly point to highlight considering it's defined in the CSIS Act, but this was actually, it took up a lot of time and discussion at the inquiry, because there were government witnesses who were suggesting that that wasn't the case. They were suggesting that the Emergencies Act actually had this broader definition. And so even though CSIS didn't actually find there were threats to the security, CSIS would have had to invest that if they thought that was the case. They didn't want any investigations to the protests because they didn't think it met that threshold. What's interesting though, and this came out when I cross-examined David Vigneault, the director of CSIS, is that even though they didn't think for this, they had to investigate the protests, they still recommended that the Prime Minister invoke the Emergencies Act, and he referenced a legal theory that somehow there was a broader reason to believe that there were threats to the security of Canada. And then when pressed on that, they would say that that was cover client privilege. So the commissioner found that, in fact, it is the same meaning, but there's a different decision maker. So even though CSIS didn't think that there was a threat to the security of Canada, there was still cabinet may still come to that conclusion. And the other thing is cabinet has different information than CSIS. They have CSIS's input, but they also have input from other organizations as well. So the commissioner pointed to threats made against public officials. So people online had made certain threats against city councillors, provincial officials, federal officials. They pointed to the Memorandum of Understanding. So that was a document prepared by James Bowder, pushed by people like Pat King. And essentially this document suggested that the protesters and the Governor General could come together and replace the government. He pointed to Diagolon, which was, I'll come back to this in a sec. Pointed to the existence of violent rhetoric online and the risk of lone wolf factors. So the idea there is that the protests themselves might be peaceful, but individuals might take advantage of the uncertainty to cause harm. So in one come back to Diagolon, I'd share my thoughts to the end, but I just want to address something about that. There was evidence at the inquiry from both Jeremy Mackenzie and Tom Marazzo also had some comments about this, that it was a joke, essentially. It was a meme. It was it's a term for Jeremy Mackenzie's fans, and and that was all it was meant to be. But the commissioner found that it grew into something more than that. His concern that he highlighted was that when weapons were found at Coots, among those weapons was a piece of body armor that had the Diagolon logo on it, and Jeremy Mackenzie was at Ottawa. So he says, although from his perspective at the inquiry, having heard all the evidence, he doesn't think there was a real threat here. From the government's perspective in the moment, that may have caused them some genuine concern. And then another point about the Memorandum of Understanding, James Bowder testified that he had no help putting this document together. The idea was just meant to be an agreement. It was never meant to be some sort of a revolutionary manifesto. And in his words, essentially, it amounted to nothing because it never got signed by the Governor General. But anyways, those are the reasons why the commissioner found a serious threat. Though the commissioner also pointed out that he doesn't consider the factual basis to be overwhelming. And he comes back to this idea of reasonable grounds. So he says it doesn't require certainty. And so even though it's a bit iffy, the government was still justified in believing that that was present. So turning away from serious threats of violence, the next big issue was that it has to be beyond provincial capacity. So the commissioner here, he was looking at things like the fact that the protests were around the country, they weren't located in one province. Convoys, the idea that, this protest was a convoy of trucks, and convoys are mobile. So if the protest got shut down in Ottawa, for example, it'd be very easy for them to move to Gatineau, which is in a new provincial jurisdiction. Also the fact that people had come from around the country to the convoy, making it a national issue. And specifically, he pointed to the fact that Ontario and Alberta asked for more officers. So he took this as evidence that those provinces couldn't deal with it on their own. They needed outside help that the federal government was providing. And that kind of brings us to our last point, which is the issue of federal laws. So the commissioner's argument, or his finding, I should say, was that it's not enough that the laws have to exist on the books. They have to be effective in being implemented. So, for example, the criminal law exists, but it has to be it has to be able to be enforced. So there were police officers that were concerned that they couldn't go in and lay charges. And another point that I'm going to come back to is the use of the armed forces. So the National Defense Act says that the government can call on the military to come in if there's no other resources available to deal with the situation. But that's a law of Canada, but he didn't think that was appropriate. I'll have some comments about that later. But those are ultimately the reasons why the commissioner found that the declaration of emergency was justified. And once the government was able to make that declaration, that enabled them to use a number of powers. So the powers came down to, you could think of them under sort of 4 categories. The first was prohibiting a number of things, making it an offense to do these things. So it declared certain assemblies prohibited if there was a threat that they would cause a disturbance of the peace. And then attending those assemblies was illegal. Bringing minors to the assembly was illegal. Foreigners coming in, so mainly Americans crossing the border, was illegal. And providing support to so donations were actually illegal as well. It also enabled police to create exclusions. So this enabled them to, for example, in Ottawa is where it was used. They declared a certain area was a no-go zone, and it gave them the authority to just kick people out without having to identify them as protesters or not. It also enabled police to compel people to provide goods and services. So really what this comes down to is towing. It enabled them to direct tow trucks to help them tow trucks. And lastly, it enabled them to freeze bank accounts. So the commissioner did have some comments on when this veered into being inappropriate. So for example, he thought freezing bank accounts at the end of the day was justified because it deterred people from going to the protest, but he did criticize the fact that there wasn't really a way for protesters to unfreeze their bank accounts. So it put pressure on people to leave, but then once they left, their bank accounts were still frozen, and there was a lot of confusion in terms of people going to their banks, trying to essentially access their funds. Also on the note of exclusion zones, as I've kind of...
Oh, pardon me, Hatim, if I may interrupt briefly. Some of our participants, including myself, are having a little trouble hearing you. Is there any way you could improve maybe the internet connection or the microphone in any way?
I can get closer to my microphone, and I can maybe I can turn off my personal video. That should keep the screen share on.
Sure, that would be, let's try that. Perhaps also you could try maybe disconnecting your cell phone if you have it from the Wi-Fi. That might boost the Wi-Fi on your laptop.
Oh yes, I will give that a go.
Okay, perfect. It's probably the CRTC interrupting our important conversation. So anyway, thanks very much, and please continue.
Okay, I just stopped my video. You can still see the screen share, right?
Yes.
Okay. So yeah, I just want to make a comment about the exclusion zones. So in this case, there were police officers that testified they normally have the ability to remove people from an area when they're conducting a police operation. This is one of the powers that police normally have. The commissioner found it was justified because he said that there's some uncertainty. The police weren't always sure if they could do that, and so this gave them the clarity. I take issue with that because the Emergencies Act is supposed to be necessary, not just helpful. And so that kind of brings me to the point in my talk where I want to talk about some of the problems with the commissioner's finding, at least as I see them. So the first one I want to address is the issue of the military I'd mentioned earlier. So the National Defense Act says that the military can be brought in when a situation, a riot or a disturbance is beyond the powers of civil authorities to suppress. The Emergencies Act, on the other hand, you'll remember it says it cannot be dealt with any other law of Canada. So how you put these together is essentially that the Emergencies Act seems like it's the last resort, and the National Defense Act is the second last resort because it is a law of Canada. So if you can use the National Defense Act, you'd think the Emergencies Act isn't justified yet. So essentially the way it would work is that you have a situation, you try to address it with the normal police measures. If that doesn't work, you can call in the military. And if that still doesn't work, you can declare an emergency. And this is actually what the people who created the Emergencies Act thought. And Commissioner Rouleau acknowledges this. So the people who wrote the Emergencies Act thought it would be better to use the military than use emergency powers. And that makes sense if you think about it, because an emergency, if the military comes in, they're still subject to the same legal restrictions as that normally exist. But the Emergencies Act lifts two very important limits on government power. It allows the federal government to create laws that normally are in the realm of the provinces. And it also allows the federal executive, so the prime minister and the cabinet, to create laws without parliament passing them first. So it takes the democratic element out of lawmaking, which is a pretty severe measure. And yet the commissioner's reason for finding that this wasn't essentially an option that had to be considered is that much has changed since then. I find this unsatisfactory. I suggest to you that it's unsatisfactory, but he doesn't provide more explanation for why the military shouldn't have been considered as an option first. It may be that our personal preferences have changed, but this is the way the law was written. So I think that is a shortcoming. The next, you'll remember I highlighted these 2 points about the risk of violence and the impact on the economy. I want to address each of these. So in terms of the risk of violence, this is the commissioner's finding that he's talking about Superintendent Pat Morris. So if you weren't following the news at the time, Pat Morris is the lead intelligence officer of the OPP. And the OPP was the police force that was doing the most to collect intelligence on the protests. And so in Pat Morris's opinion, he thought the lack of violence was shocking. That was his word. Because if you have a big event like Canada Day, there's always going to be a little bit of violence. And if you have Canada Day for 3 weeks, it would be shocking if there was no violence, which is what he found here. And he found, or in his opinion, the media was misreporting things in a way that was exacerbating the situation. So the commissioner here says essentially that he just disagrees, that there were other witnesses who said there was violence, and he prefers their opinion over Superintendent Morris's. But I want to point out just an example of what that testimony about violence looks like. This is the testimony of Steve Bell. So he was the interim chief that replaced Peter Slowly after Peter Slowly stepped down. And he was asked, when you use the word violence, you mean felt, not actual violence, right? And he says, that is correct. Not the criminal code definition, but violence that was felt by excessive horns being blared and having trucks run 24/7 a day. Again, I'm going to suggest to you and draw your own opinions, but that's not what's meant by serious violence under the Emergencies Act. And to be fair to the commissioner, this is one testimony. There was other people who testified about violence, but in every case, they didn't see it themselves. They were talking about what they had heard from other people. And so there was never throughout the whole inquiry, the only evidence about the specific, people actually witnessing violence was the testimony of protesters saying the violence they experienced from police officers when they were kicked out of Wellington Street in front of Parliament. So turning to the other point, which was the issue of the impact of the blockades, the Emergencies Act was invoked on February 14th. And the 2 major blockades were at Windsor and at Coutts. So here at the top, we have Superintendent Dana Early. So she was essentially in charge of the OPP response at Windsor. And she's confirming there that everything was cleared by February 13th, the day before the Emergencies Act. Curtis Zablocki was the deputy commissioner for the RCMP responsible for Alberta. And he's being asked when protesters decided to leave Coutts. Middle of the day, February. Essentially what happened is I'd mentioned the weapons that were found earlier. That police action was done on the night of the 13th into the early morning hours of the 14th. And essentially the protesters were shocked. They didn't want to be associated with these, people having guns and planning violence. So they decided to leave to separate themselves from that. And so they agreed that day. And then over the next couple of days, they left voluntarily. The commissioner acknowledges this, but he points out that the risk was that the protesters would come back. But I would suggest to you, and it seems to me like if the police could clear them out in the first place, they could prevent them from coming back again. Another point is, I want to address is about the issue of tow trucks and how needed they were. A lot of time was spent on tow trucks, and my colleague Rob Kittredge spent a lot of time cross-examining people on this point. But I think the commissioner here is he's not grasping what the actual evidence was. So he points out here that the OPP said that they could clear the protests without the tow trucks that they had been speaking to, but that's not actually the evidence. The evidence. So Superintendent Robert Bernier was the event commander for the Ottawa police. So he was in charge of trying to clear the protest. And my colleague, Rob, asked him, tow trucks were helpful, but they weren't necessary, right? And he agreed. After the 13th, the tow trucks, he says things materialized. Elsewhere in his testimony, he explains essentially he saw all the tow trucks show up. And so that gave him confidence that they were good, in his own words. So those are some issues I want to highlight. There are some other ones, but I think those, that's enough for this short talk. And perhaps they might come up in questions, but I think those are some of the big ones. So that takes me to the recommendations. There's over 40 of them. I'm just going to highlight a few that I think are particularly interesting and important. One are recommended changes to the Emergencies Act. Commissioner Rouleau he recommends that the definition of a public order emergency be modernized. Elsewhere, he suggests that the definition should be separated from the CSIS Act. Now, while Commissioner Rouleau, I think he rightfully points out that the standard should be kept high, it should be kept an issue of last resort. Something that maybe if this is of interest to you that you'll want to pay attention to over the next few months, years, is that if this change goes through in the government, that they do it the way that they make sure the threshold is high. Because once that debate gets started and the Emergencies Act is being changed, it's very easy for a lower bar to be instituted. Another thing is how the inquiry is actually managed. So the commissioner here is essentially asking that in the future, the government should have to provide their argument for why the Emergencies Act was justified at the outset, so that when the evidence is heard, it can be measured up to that standard. So I'd mentioned earlier how the CSIS director had said essentially there was a legal advice he'd received. That's why the Emergencies Act was justified, but he couldn't say anything more about the legal advice because it was privileged. So solicitor-client privilege essentially means that if you get advice from your lawyer, neither your lawyer nor you have to answer questions about it. And that's a good rule. It protects your ability to receive legal advice. The government has the same ability. But in a situation like this, when their justification is the legal advice, essentially no one knew what that legal advice was until after the fact, until they made their arguments. And so it hurt the ability of the commission to draw out the evidence that it would have been helpful. And it hurt, like for me, my colleague, and the other parties, we don't know what questions to ask because we don't know what the government's justification is. And then the last recommendation I want to address is actually one I don't think is too bad, but I've seen a lot of people talk about it and I get why it's concerning. The commissioner recommended that there be some sort of an agency or department responsible for monitoring social media. So that has the potential to be very intrusive, but I think what the commissioner is getting at is that throughout the inquiry, we heard evidence that the police essentially didn't know what was happening. It caught them by surprise. I mean, I know I was watching on Twitter, and if you were following at the time, you could see videos of kilometer-long trails of trucks crossing the country to Ottawa, but the police were still caught by surprise because no one was looking on social media. So I think it's fair to say someone should be able to look at this thing that's public and keep the police up to date. But if it goes beyond that and tries to identify people or profile people, that could be concerning and something to watch out for. So I want to conclude with a few thoughts about what this all means and the implications of the act being invoked and the commissioner finding that it was justified. I was disappointed with his finding. I wasn't quite surprised, but I was disappointed, and I know a lot of people were. And it is disappointing because it essentially approves the government's actions, but it's not the last word. So two things I want to point out. One is that the report it's not legally binding. It's just an investigation. The commissioner made his findings, but at the end of the day, what actually has legal effect is the judicial review that's currently before the courts. So the Justice Center and other organizations are in court to have the court assess whether or not the Emergencies Act was justified. And if so, that declaration can be found unjustified, and that will actually have legal precedent going forward. So that's something to look out for. That's going forward in April. The other point is that, like I said, his report doesn't have legal effect. Its effect is persuasive. It's supposed to be keep the government accountable by essentially highlighting what actually happened to draw it to attention. But essentially, its effect comes down from persuading you and persuading other people who wield authority in our country. And so there's one more layer of accountability, and that's that all the evidence is public. So if you disagree with his findings, you can actually go to the website. You can watch people testify. You can look at the exhibits yourself. Now, there were tens, if not hundreds of hours of testimony. There was thousands of pages of exhibits. So if, I get that, if you're not doing this as your full-time job, that's a lot to do. But there's a lot of good sources out there, including the Justice Center. You can go to our website and see some updates that I did during the inquiry. You can see, you can watch our cross-examinations, or find, a news source that you agree with and that you trust. And you can see what they've kind of pulled from this and draw your own conclusions. So at the end of the day, the facts are out there. If maybe you're convinced, but you want to try and convince a friend, you can always point them to the evidence. And I think that is very important that's out there. And that's a plus. That's an actual good thing that came out of this whole process. So that brings me to the end of what I had prepared. If you want, if you're interested, go to the jccf.ca and you can see more about our work on the commission and some of the videos I've mentioned. And I believe this takes us to the question and answer period.
Well, please join me in thanking Hatim Kheir for that really informative and excellent presentation. Like we've said, the final report was delivered to Canadians in 5 volumes, over 2,000 pages. And so I feel very glad to hear about the kind of the most relevant, interesting findings of the report. So as Hatim mentioned, we are now moving to the question and answer period. Once again, I would invite you to submit your questions to us via the chat. If you can, I would ask that you format your question as I have done in the chat, just a question, colon, and then the question. That helps us identify the questions from the conversation in the chat. And then I will invite you to turn on your mics and ask your question of Hatim yourself. Again, there are 185 people signed up, so please keep your questions short and sweet, and we can hear from more people that way. Okay, so one of our participants today asked a question that I myself had. Shirley Dolan, feel free to turn on your mic and ask your question.
Hi, can you hear me?
We can hear you. Okay,
that's great. My question, thank you very much for this presentation, by the way, it was excellent. My question was, do you think that the report will help or hinder the cases that are going forward, the court cases that are challenging the Emergencies Act invocation?
Thank you for that question. I'm going to try with my video. Luke, let me know if you're having any issues, but I'm not screen sharing now. So that's a good question, and it's something I know me and Rob have been talking about, and I'm sure the lawyers on the judicial review have been talking about. But honestly, it's probably not helpful. I think, if I was, I'm not on the judicial review. I'm not working on that case. But if I was, my approach would be you should decide differently than Commissioner Rouleau did for maybe some of the reasons I've talked about today. It's not binding in any way on the courts, so the courts can disagree. So that's kind of where it leaves things.
Thanks, Hatim. Erica McIntyre has a similar question. Please ask your question, Erica.
Hi, hopefully you can hear me. My question was similar. I just also wondered if the courts do have a result that is in conflict with the Ruler report, what would that mean ultimately? Does one have more weight than another if the Ruler report is only persuasive, for example?
So if the courts find that the declaration of emergency was unjustified, it would, in a sense, it would kind of be the winning voice. It would be binding on. So this would be a decision of the federal court. It would be binding on the federal court. It's a legal decision that would have a strong effect on other courts. And presumably, if this situation ever came up again, it would be back again before the federal court, and so they would have to follow the previous precedent. So in that sense, if a future government wanted to declare invoke the Emergencies Act, they would have to be aware of the fact that whatever the Rouleau report found, courts are going to have to be following this other precedent. So in that sense, there's good reason to hope that the judicial review goes differently.
Okay, excellent. Now, Gerald Warwick, I am not doing well pronouncing your name, but Gerald asked a great question about bias in the commission and about the threshold for reasonably invoking the act. So Gerald, please, the floor is yours.
Thank you, Luke, and don't worry about the name. It took me 6 years to learn it too. So I have two questions. The first one, how is it that in a democratic system that the government gets to pick their own judge? And the second question I have is how can he reasonably find that, if this happened, this could happen, that could happen, meets the tests that the emergency has to meet to exist and to invoke the act? Did I ask that clearly enough?
So I'll address the first part of your question. I may need you to clarify the second part, but in terms of the first question there, this is something I've heard a lot of people worried about, and I think it's a fair concern. I've heard some people suggest that what should happen is that the other parties in Parliament should have a say on who the commissioner is. But the unfortunate reality is that at the end of the day, the commission, even though it has independence from government, it is a creature of the government. It's been created by the government. Someone's got to pick the commissioner, and so it almost follows that it's gonna be the government picking it. In some sense, I mean, every judge is appointed by the government. Now, there's kind of a check there because it's not always this government that appointed them. So when someone goes to court against this government, it may be that a previous government appointed the judge, and they don't get to pick which judge hears the case. So the situation's a little bit different. But that's the problem. Kind of highlights something that's almost baked into the idea of a government, which is that when you go to court against the government picks who decides the case, right? Though I do think that in the case of something like the Emergencies Act, a better process could be set up to pick who the commissioner is, and specifically something like getting input from the Conservatives, for example, getting opposing sides to actually provide their viewpoint. At the end of the day, it's always going to be some aspect of either Parliament or Cabinet that's picking the commissioner, but I think that would at least be a little bit better. And could you remind me the second question that you had?
Sure. I'm just having trouble with how he can find that, well, if this happens, this could happen. Potential hypothetical situations he's using to justify the emergency exists. How I have trouble with that.
Okay. Yeah, I think I share some of your concerns. I think what he's working off of, though, is a lot of the evidence that we heard during the inquiry. So there were a number of political officials, especially from the federal government, that highlighted all sorts of concerns about how things might go. Unfortunately, part of the process is that the time was so constrained that it was hard to have enough time to cross-examine people, to pull apart every sort of idea that they threw out there. So, for example, when some officials were saying that they were concerned that if they if they cleared the protest, and so here's an example, they cleared the protest in Windsor the day before the act, but then they said they were still concerned that the protests might return because it's mobile. Well, the issue there is that, I think there is an argument to be made that if you can clear a protest, you can prevent it from showing up once you know that to be on the lookout for it. But again, it's hard to challenge all of that in the short time frame of the inquiry. The police threw these concerns out there, and the commissioner picked them up, unfortunately.
Thanks very much. And I'm going to advance a question of my own, sort of a variation on Gerald's. You said that a recommendation of the final report is that the definition of, I guess, the threshold that has to be exceeded under the Emergencies Act was similar to the definition in the CSIS Act, and that this caused some confusion in the commission, and that there's going to be an attempt, or at least a recommendation, to make these two definitions distinct. In your, is that going to be harmful or helpful to rights and freedoms in Canada if a situation like this occurs again?
I think it's harmful personally. So Leah West was one of the academics that was invited to speak at the policy phase, and she made a very good point, which is that the Emergencies Act doesn't get used. I mean, it's only been used once, right? And hopefully it doesn't get used for another 30 years. And so there isn't really precedent about how to interpret some of these terms. And so it's almost like every time it pops up, it has to be considered afresh. And so the advantage of incorporating the CSIS Act is that there are cases that interpret the CSIS Act. CSIS has to interpret the act every day, but there's also court cases that look at that and set out some principles. And so those, by building up that body of principles, the court can then, the government, if they have to consider declaring an emergency, they can look at those principles. And then if it gets challenged, the courts can look at that as well. And so threats to the security of Canada, yeah, it is a very narrow definition, as I think it should be. And I think, all the concerns that made the government narrow the definition of the CSIS Act, so the CSIS can't investigate people too broadly. That's even stronger with the Emergencies Act, that applies not to one person or a group of people, but to the whole country, and that lifts the normal limits on government power that exists. So I do think that link should be kept, and it's unfortunate that recommendation was made.
Thank you very much. Our next question comes to us from Kimberly Smith App, and I believe that Martine has a similar question as well. Many Canadians are incensed about the way that Justin Trudeau characterized the participants of the Freedom Convoy in 2022. So with that, Kimberly, can you advance your question?
Just trying to look for it as well. Anyways, I just want to know, he's in front of a justice, Justin Trudeau, and clearly he lied. There's evidence all over the media, the words he spoke, what he called people. So in front of a justice, if he's sitting there actually lying, can he not be held accountable for that?
So I know the comments you're talking about. I almost included an excerpt from the report about that, but I had other things to talk about. But I think the issue is, all right, so there's a few things. What would holding him accountable look like? Essentially, that's a perjury charge. That's what the law about lying under oath is, and that's what the allegation is here. So to lay a perjury charge, I believe, if I'm remembering correctly, requires the consent of an attorney general. So no, you could actually lay a charge against your neighbor if you wanted to, but you can't lay a perjury charge against your neighbor. And so essentially what you're asking is, would another government do this and try and pursue this against him? And then the other layer to it is that perjury is actually very hard to prove. It's not often that people are found guilty of perjury, even though people lie under oath all the time. And that's because perjury requires not just that you said something that ended up not being true, but that you purposely said something that wasn't true. And so if you actually look at the report and what the commissioner says about the prime minister's comments, the commissioner essentially says, I think his initial comments, the one he made in the interview back in 2022, I believe it was, or it might have been 2021. But those initial comments were unfortunate. He should be clear about what he's talking about, but essentially that the prime minister's explanation that he was just talking about a few people who were spreading misinformation. He didn't mean to call all unvaccinated people a fringe. That's not what he meant. I think his you probably know what he meant, but his comments are vague enough that I think that's at least plausible, and certainly not beyond a reasonable doubt that he was guilty. So I think it's unlikely that he would be found in any way guilty of perjury for those comments.
Thanks, Hatim. So the next question is about evidence, right? The government and the commission had access to all sorts of evidence to which the average Canadian just doesn't have access because of redactions. So a question about evidence comes to us from Judy Neilson. Judy, the floor is yours.
Hi, did the federal government release all the documents requested of them?
No, they didn't. So there were, this was actually an ongoing battle throughout the inquiry in terms of requesting redactions and getting them kind of late and not being able to use them either because the witnesses that they're relevant to have already testified, or because, the witness is coming right up and so you don't really have time to digest it. And so a good example of this is my colleague Rob Kittredge's cross-examination of Justin Trudeau, where a fight, a legal argument over redactions being released was happening the night before the prime minister testified, and then ultimately those redactions were released an hour into his testimony. So it was already 10 a.m. at that point, and luckily we had the two of us, so I happened to find that if you compare the redacted version to the unredacted version, you see that what they redacted was that the Americans were offering tow trucks, and it was redacted for being irrelevant. So my colleague put that to the prime minister, but then it sort of worked out. We didn't do this on purpose, but the Canadian Constitution Foundation went right after us, and they cross-examined the prime minister, and the prime minister was like, "Oh yeah, this report is very great. I think everyone should read it." And so the lawyer pulled up the report, and it was just page after page of black redaction. So that was an ongoing issue. The commissioner's report does make some suggestions about how redactions should be addressed, certain ones that just shouldn't be used in the future, and others he says there should be a working group put together where some of the commission's lawyers can look at what's behind the redactions and determine in advance what should be redacted and what shouldn't be. That would be an improvement for sure. But at the end of the day, I think a purpose like this is about accountability. It's about getting to the bottom of things. And so the government should be very, I get that there may be certain things they have to redact, but they should be very sparing in using that, which wasn't the case in this situation.
Thank you.
Great questions so far. Thanks everyone for advancing your questions. Questions help us think differently and more creatively about these subjects as well. So please keep them coming. While I'm waiting for other questions, Hatim, I have one of my own. So one surprising feature of the report is that the definition of serious violence seems to have changed a little bit. My thinking is that a serious violence will always be a criminal code violation. But now it seems like serious violence counts as things like honking a horn or causing people to feel uncomfortable or offended. Is this just sloppy thinking in the report, or is this sort of an intention to set a precedent about what counts as serious violence in our country?
I think it's probably more the former. I think there's in my opinion, I think there's a bit of muddling going on where on the one hand, the commissioner can point to things like threats against public officials. That would be serious violence. Someone, some crazy person, we saw at the inquiry, they have examples of this. Some crazy person says, I'm going to kill Justin Trudeau. That's serious violence. Murder is serious violence. But we also heard evidence that there were no credible threats, no threat that the RCMP or anyone actually thought they had to investigate and track down. But then you have other situations where, definitely there was honking going on, but that's not violence, but then it gets testified as violence. And so I think there's a muddling that's happening at various points where witnesses are testifying and using the term violence in an in an incorrect way, but in a non-specific way to include this broader idea. And then the commissioner relies on that to say that people saw that there was violence. And then he can also reference things like the threats, even though those weren't further investigated. And so it's easy to say, oh, there's serious violence because of, the examples that I listed, but each one, when you actually break them down, kind of doesn't hold water, in my opinion. And then that was further complicated by the time restraints, where when we're, sometimes we had 5 minutes to cross-examine someone, you really got to pick the point that you want to hone in on. And sometimes comments like that end up going through.
Okay, excellent. So it is now 12:59 in Calgary. Thank you all for asking many excellent questions. Thanks most of all to Hatim for sharing his time and his expertise with us. It's very appreciated. These conversations are actually a really special opportunity for Canadians like me to learn about these complicated legal and social issues from an expert perspective. I don't know if many of you know this, but these events actually count as continuing professional development credits for lawyers in certain provinces in our country. So you're kind of getting to see an analysis of these complicated issues the way a lawyer might see them as well. So I'm really grateful for the opportunity, and I'm hoping you all found this really valuable as well. So please keep in mind, again, the Justice Center is entirely funded by generous Canadians like you. If you're so inclined, please make your way to our website and consider making a donations today. It would be very appreciated. We are entirely funded by Canadians. We don't accept any government funding. So also, please stay tuned for more events in this series. We're going to be hearing from lawyer Keith Pridgeon in April about digital ID, surveillance, privacy, and risk. This is a really important emerging issue, and it's an issue upon which you have spoken as well, Hatim. So we're looking forward to that. Feel free to share the In Conversation series with your friends and family. We would like the series to continue growing. So for now, thanks again, Hatim, for your time and your expertise. Thank you all for joining, and I look forward to conversing with you again soon.